from the list matter.
Transfer case from daily list.
to withdraw.
नहीं मतलब इसमें सिमिलर ऑर्डर हुआ है आप ही का सिमिलर मैटर
सीरियल नंबर
50
पोस्टमार्टम कल आ जाइए ऑर्डर दे दीजिए इस ऑर्डर को लगा दीजिए
From daily list, my item number 6, 15 minutes.
we don't adjourn matters on mentioning.
Transfer case from daily list at 10:30, item 29, the rupees 91 of 2023.
Lordship, I have not examined properly, Lordship, so I want to file counter due to this case.
You need the assistance of the client to understand an order.
No, Lordship. I have
You have
seen
seen the
instruction
order?
file.
The judgment is very specific and clear. Your lordship's judgment will not LP.
I will,
Your
Lordship,
lordship,
I will file counter evidence.
only legal issue is involved, my lord. Only legal issue is involved. Interpretation of
Any debate.
interpretation of National Coal Wage Agreement at para number 15, my lord, of LPA judgment, my lord.
You have seen the honorable single judge's judgment also.
My lord, I
He has
have
interpreted that provision.
yes, my lord, yes, my lord.
कौन सा केस नंबर है? This is
ये my
LPA
lord
number
है WPL
273 of 2020
20.
and WPL
PL
number
5398 of 2005.
5398 of 2005.
5. They have certified standing order of the
The
SSBC.
learned counsel for the parties are present. The matter relates to compassionate appointment to petitioner number 1 who has been denied the same on the sole ground that the deceased employee was a badli worker.
He was
The-
not permanent employee.
The learned counsel for the petitioner submits that the issue involved in this case is squarely covered by the judgment passed by this court in a WPL number 5398 of 2005, which has been affirmed in LPA number 273 of 2020. The learned counsel for the respondent submits that he has to examine this case and he prays for a short adjournment to file a counter affidavit in the case. Let the counter affidavit be filed by 6th of March. Would you like to file any rejoinder? 6th of March, close this case on 11th of March 24 under the heading for final discussion. Next. Sixth of March, then on 11th March, right? Next.
From daily list at 15 p.m. This case item 2 for final sold WPS 3315 of 2023.
कल ना इसी से रिलेटेड एक मैटर और कल के दिन में याद रखिएगा उसमें भी 11th मार्च को पोस्ट टुमारो के लिस्ट यस पिटिशनर वेयर इज द रिस्पोंडेंट Give me the foundational dates and then you argue.
Mine. 17/5/92. I joined as a deputy clerk. Second, 31st of December 2010, I was transferred and accordingly I joined on 31st January 2011 at Chatra. Again, 19/4/12, I was transferred from Chatra to SDO and accordingly I joined on 20th of April 12. 19th I transferred and joined. Thereafter, on 31st of December 18, I retired from service after completion. This is the background. When I was working as a project director, and in meantime I got promotion as per my seniority list, everything. in the present case, I have challenged the Annexure 3, page 49, the memo which has been issued on 1st of June 23, whereby a decision has been taken for initiation of departmental proceeding under 43B for the occurrence which has already been taken in between 2011 to 12. That is 15 months I have remained in district of Chatra. That is important. Before issuance of this resolution till 31st 12/18, I was not put under suspension, nor any resolution has been issued. That is important. Nor the resolution has been issued by the respondent for initiation of the proceeding. In 2018, a memo of charge has been framed by the Deputy Commissioner Chatra, which was served to me. I filed the reply in July 18 itself. Thereafter, on the basis of my reply, filed, opinion was sought for by the Urban Development Department. But till this present resolution has been issued in June 2023, no opinion has been furnished by the Urban Development Department, and the one counter has been filed by the authority of the Urban Development Department, which also reveals that after filing of my reply in July 2018, opinion was sought for by the Deputy Commissioner Chatra, who had framed the charge. And even then, Deputy Commissioner Chatra had not response on that till date, as evident from the counter. And therefore, my humble submission is before your Lordship. Since the no resolution, no memorandum has been issued by the department for initiation of departmental proceeding, directly first time proceeding has been initiated under 43B for the event which was taken in the year 2011. And therefore, in terms of 43BA Roman 2, bar, and on this question,
Where is the charge sheet?
my lord,
Where is the charge sheet? Charge memo.
charge me. It is at page 53. 53. It was prepared by the Deputy Commissioner in 2019, 12, 17. It was sent to the Urban Department.
You read page number 49 first.
My
Page number 49.
49. 49 is a under challenge.
Yes, read it.
May I please? चूंकि झारखंड के राज्यपाल को विश्वास करने के कारण श्री रविंद्र कुमार सिंह सेवानिवृत्त स्वयं भू अर्जन प्राधिकारी चतरा in the year 2011 I joined विरुद्ध स्वयं योजना अंतर्गत केंद्र सरकार द्वारा स्वीकृत डीपीआर से भिन्न 250 आयोग लाभों को चयन करने, जिससे योग आहत लाभों को सौभाग्यता सुनिश्चित नहीं हुई, विभागीय निर्देश का उल्लंघन करने, सुरक्षा तंत्र बरतने, पद का अनुरूप दायित्व निर्वाह नहीं करने, सरकारी राशि का दुरुपयोग होने से संबंधी आरोप जैसा कि नगर विकास आवास विभाग झारखंड रांची के 19/1/18 दैट इज on the basis of charge sent to the by the डिप्टी कमिश्नर to the urban department के माध्यम से उपायुक्त चतरा के पत्रांक 19/12/17 द्वारा गठित आरोप पत्र से प्रतिवेदित है प्रथम दृष्टया प्रमाणित पाया है. This is what your lordship will kindly see. I
Where
will
is
come
this
to the
document?
counter affidavit.
19/1/2018. Where is that document? Where is that document? 19/1/2018.
19,
19/1/2018.
that is as page 51.
Yes.
51.
Yes.
DC has framed the charge. He sent to the urban department, and urban department sent to the personal department. He was sent, and after this,
So
I
the
was-
charge was framed on 19/1/2018. The charge was framed on 19/1/2018.
that was the later.
No, charge is framed. Prapatra K is also there.
हाँ, प्रपत्र का is a frame by deputy commissioner.
That's right. But
It-
Prapatra K has been framed on 19/1/2018.
That was framed on 19/12/17 by the deputy commissioner at page 53. It was sent to the urban department,
That's right.
and urban department has sent by 19/1/18 to the personal department, and thereafter I have been asked to reply this memo of charge. I filed the reply in July 18, that is admitted position, and after filing of my reply,
Where
to
is your
the-
reply in July 18?
that is in the counter they have been told.
You have not disclosed it in your writ petition that you responded to it.
That I have I have does not
Annexure 3,
include,
let us
but
see.
I have disclosed that fact.
Just a moment.
The first counter, which was filed in August 23, in counter reply has been included, which was filed in 25/7/2018, page 37. The first counter.
Anyways, you continue. You responded by which letter? You have not mentioned it in your list of dates.
It was sent to me by letter dated 10
Your list
May
of dates
18.
is so sketchy. The relevant dates are completely missing. You have not mentioned about 2017. You have not mentioned about 2018. Nothing has been mentioned. It is the same synopsis which you have filed in your writ petition. The foundational dates are not there.
Since
You give a list of dates.
date may come up day after tomorrow, I will.
I'm hearing you.
Everything
You just
is
finished
on
it.
record.
No, it may be on record, then why do you need to file a list
I
of
am
dates?
sorry. I am sorry.
You don't even mention the age of retirement in your list of dates. Nothing has been mentioned. Then you will file a review petition that this fact has been omitted. When did you respond to this?
25/7/18. We have mentioned it.
25/7/18
18.
response.
Letter number 1114.
Okay. This is where In supplementary counter affidavit.
Main counter.
Main counter, August.
Page 37.
Okay. And then he retired on 31. After 25/7/18, what happened?
Thereafter, Lord said the correspondence was going to the department
Okay.
with any acceptance of his Sokoj or not.
Okay.
But in the meantime, he had superannuated on 31/12/2018. So after his retirement,
When was the Prapatra curve framed?
prior to his retirement,
Prior to his
it is admitted, Lordship. It is 19/12/17, Lordship. 19/12/17, Lordship.
But
Prapatra curve.
no resolution has been issued till my retirement or initiation of proceeding on the basis of the charge frame. First time, and therefore, by order
Who was the
dated,
authority who was supposed to take a decision with regard to
that is
initiation
personal
of department?
Personal department.
Some authority must be there, not the department. Some authority. Who was the authority?
Secretary of the personal department.
The present impugned letter has been issued by the secretary,
Mine. Annexure 3.
joint secretary.
कार्मिक प्रशासन सुधार राजभाषा विभाग। केवल हम थोड़ा सा फॉर क्लियरिफिकेशन के लिए क्लियरिफिकेशन के लिए डीसी ने चार्ज फ्रेम किया। डीसी ने चार्ज फ्रेम करके अर्बन डेवलपमेंट डिपार्टमेंट को भेजा कि ये अर्बन डिपार्टमेंट ने पर्सनल को भेजा। पर्सनल ने हमको दे दिया कि देखिए आप पर डीसी ने ऐसा ऐसा किया, इस पर क्या बोलना। हमने 25/7/18 को बोल दिया, जवाब दिया। मेरे जवाब डालने के बाद बाय द पर्सनल डिपार्टमेंट लेटर हैज बीन इशूड टू द अर्बन डिपार्टमेंट इनक्लोजिंग माय रिप्लाई कि इस पर आप ओपिनियन दीजिए। Whether the explanation given by me is acceptable or not, वो 18 से 22 तक कुछ नहीं किए। अर्बन डेवलपमेंट डिपार्टमेंट ने जनवरी में काउंटर फाइल किया कि आफ्टर रिसीविंग द लेटर बाय द पर्सनल डिपार्टमेंट ही ऑल्सो सेंड माय रिप्लाई टू द डिप्टी कमिश्नर चतरा, बट ही डिड नॉट रेस्पॉन्ड टिल डेट। दैट इज द एफिडेविट, काउंटर एफिडेविट फाइल। And after expiry of near about 5 years, in 23 June, पर्सनल डिपार्टमेंट हैज टेकन। मेरे जवाब का ओपिनियन का आज तक they have not taken any final decision on the basis of reply filed by me to the memo of charge which was framed by the deputy commissioner, nor any memorandum like the Annexure 3 has been issued for deciding. Just by Annexure 3 they have decided to initiate a proceeding. If they have initiated proceeding during my service period, then that should be under classification control appeal rule, and if they initiated, that should be converted into 43B after my retirement. That is not a case, and therefore, Your Lordship, only one order I want to place. Order dated 19/12/23 passed in this case by a coordinate bench. 19/12/23. May I please? Learned counsel for the petitioner submit that the petitioner joined in service as so and so. Thereafter, by order dated 31/12, he was transferred to Jatra as a district land acquisition officer, where he joined on so and so. Subsequently, he was transferred to Chaivasa as the SDO on 19/4/12, where he took charge on 20th April 12. He further submit the petitioner retired on 31st/12/18. However, proceeding under 43B has been initiated in the month of June 23 for the charge while he was posted as DLO at Jatra way back in the year 2010. He further submit that the charge which has been alleged to be given to the petitioner was actually internal communication copy which has given to him, which duly replied on 25th of 18 itself. Subsequently, government took 5 years and finally proceeding was initiated after taking the permission of the governor in the year June 2023. As such, as per the provision A Roman 2 43B, entire initiation is bad in law. Learned counsel for the respondent submit that the charge sheet was initiated way back in 17 when the petitioner was in service. As the matter of fact, in June 23, it was only conversion. There was no earlier memorandum. There was no earlier decision to initiate the proceeding. Where is the question of conversion of the proceeding? The proceeding was well initiated prior to his retirement on a specific query to the fact by this court that whether at the time of issuance of memo of charge, whether the inquiry officer, place of proceeding, presenting officer, etc. were appointed at the time of issuance of
Yes,
the
sir.
alleged
What do you have
charge
to
sheet
say?
of
Respondent?
18 or same has been issued in the year
Yes, respondent. What do you have to say?
2023 and in
Just a
pursuant
moment.
to this
You
order.
just- Sir, please hold on. Yes.
But the thing that the person has initiated at the while he was in service lawsuit, it was only converted under Rule 43B law.
No.
Since
Who was the authority who has initiated the proceeding?
yes, Lordship.
Where is that letter by which the petitioner was asked to to respond?
Yes, yes, Lordship.
Where is that letter by which the petitioner was asked
36, page 36, or first counter, Lordship, page 36.
to? Page number 36.
The proposed charge Lordship स्पष्टीकरण समापित करने के संबंध में पेज 36 10/5/2018 Lordship.
Yes. What is it? Read it.
श्री रविंदर कुमार से issued by the parent department Lordship. निदेशानुसार उपयुक्त विषय के संबंध में कहने कि नगर विकास एवं आवास विभाग झारखंड पत्रांक 97/19/2018 के माध्यम से उपायुक्त चतरा का पत्रांक 19/17 द्वारा आपके विरुद्ध प्रपत्र क में आरोप गठित कर उपलब्ध कराया गया है, जिसमें आपके विरुद्ध विभागीय निर्देश का उल्लंघन करने, सुचारिता करने, पद के अनुरूप दायित्व निर्वहन नहीं करने, सरकारी राशि का हानि करने तथा वित्तीय अनियमितता संबंधी आरोप प्रवर्तित किए गए हैं। अतः अनुरोध है कि उक्त आरोप का स्पष्टीकरण एक पक्ष अंदर उपलब्ध कराने के बाकी है। And this is what has been given in the explanation of the Rule 43B, Lordship, which we have quoted in our counter affidavit also, Lordship. If Lordship will see page 17, Lordship, of para 17 of our counter affidavit.
Just a moment.
Para 17 kindly, Lordship.
Para 17.
Yes, Lordship. Same counter, Lordship, same counter.
Yes.
That with respect to the issue that the proceeding is barred in view of Rule 43B of Proviso A2 of the Jharkhand Pension of 1950, is pertinent to refer to the expansion of Rule 43B of the Jharkhand Pension of 1950, which is being reproduced here as under. For the purpose of the rule, departmental proceedings shall be deemed to have been issued when the charges framed against the pensioner are issued to him, or if the government servant has been placed under suspension from earlier date or such date, and judicial proceedings shall be deemed to have been suited. So when charges have been framed while he was in service, Lordship, so there is no error, Lordship. Only there has been a conversion, Lordship.
Para number 18, you said of first counter, no?
17, Lordship, in which we have quoted, Lordship. There are 17, we have firstly quoted the Lordship, the rule, Lordship, and thereafter, Lordship, we have given the dates in paragraph 24 onwards, Lordship. In last line, as such, it is most humbly stated and submitted that since the so-called charges framed against the petitioner was issued to the petitioner by Department letter number such and such 2018, Lordship, by as a department person against the petitioner is deemed to have been comments with effect from 10/2018. Our decision to proceed further in the case of the petition was taken by Professor.
Where is this 10/5/18 document?
The text was not just now, page 36.
By which he was given a show
Yes,
cause.
yes.
So this is the date you say that the charge was framed and communicated to him. He was asked to give an explanation. If there could be two situations, either he would have accepted whatever the charge is, then there was no question of any departmental proceeding.
Then only some
Then
punishment would have been
some
imposed.
punishment would have been automatically imposed. But still, if he
Since
denies
there-
the charges,
yes,
then
yes.
there is a question of giving him an opportunity and then.
Hearing lordship and offer for the
But the
evidence.
charge stood framed on 10/5/2000.
Prior to his
This is your
retirement
case.
also.
This
This
is
is
your case. सुन लिया इनका केस.
हाँ.
Now you respond.
और वो तो हमारा माने the question, the point which has been raised by my learned friend has already been answered by this court. That
Where is
I will show to you.
Please show. Please show. Where has that question been answered by this
In
court?
pursuant to 19/12/23 order passed by this court, they have filed the counter. They have said to no inquiry officer, no
No,
nothing.
maybe not, may not have been appointed.
What they have said? They have said in 2023, your lordship may
Where,
kindly.
which paragraph are you referring?
That I am coming. Your lordship, annexure 6.
No, you refer to the paragraph of the
That
supplementary
I am
contract.
coming to. Page 58, your lordship.
Page 58 of
50
supplementary
of
contract.
my REIT application.
You were referring to some paragraph of supplementary contract. First you refer to
Later on, I will come to my lord. The issue which he has raised before your lord.
page number.
That the page 58 of my REIT application. Thereafter, I will come to it. Relevant paragraph. Page 58.
58. Yes. This is a part of some judgment.
My lord, the issue raised has been answered. Therefore, I am placing those.
Place it. What was the fact of that case? Can you place that also?
The fact of the case was, in this case, my lord, petition was initiated,
Place
proceeding
it
has
from the
been
judgment.
initiated.
Place it from the judgment.
Start page 54. Petitioner has challenged the order and contains so and so decision has been taken to deduct the 5% amount of the pension of the petitioner. Submission has been made on behalf of the London Council for the petitioner that he has joined the government service on so and so post of EA and rendering continuous satisfactory service of 34 years in Department of so and so Ranchi, and on 30th of November 2000, while he is working under Water Resources Department of Jharkhand. After retirement, pension of the petitioner was paid. He started receiving his pension from Sachivalayat Agency. No departmental proceeding ever initiated against the petitioner while he was serving. The petitioner received the copy of a resolution as contained memo number dated 28/7/2009, issued under signature of Under Secretary Water Resources, wherein the decision to initiate the departmental inquiry against the petitioner was taken to be initiated 43B of the pension rule. Accordingly, petitioner was directed to submit his defense reply within 2 weeks. Memorandum of charge dated 27/7/2009 was enclosed, wherein the allegation was leveled against the petitioner for commission of financial irregularity in the matter of construction of the dam of so and so. London Council for the petitioner submit. The petitioner since retired on 30th of November 2006, alleged occurrence took place in 29/3/2004 during his posting between 17 to 2004 to 9/10/2004, which the petitioner has stated in reply to his so-called. As such, the submission has been made the cause of action is barred by the 4 years provided under Proviso 1 Roman 2 to the Rule 43 of Pension Rule. The submission has been made on behalf of the Lord Constitutional the petitioner that the proceeding under 43 can be only be initiated within 4 years from the date of proceeding, but the instance case alleged offense took place in the year 2004. As such, same is barred by the limitation that is 4 years as provided so and so. Further submission has been made on behalf of the Lord Constitutional petitioner that he has also objected before the inquiry officer regarding maintainability of the entire proceeding, and the inquiry officer has also accepted the reply by giving its opinion that in view of so and so, thereafter matter has been referred to by the conducting officer before the discovery authority for taking appropriate decision in this regard. Further submission has been made by the Lord Constitutional Tribunal order dated 19/2/2014 is otherwise also bad because the discovery authority has imposed the punishment without application of mind so and so. Direct consequence further submit by referring the inquiry report which has been annexed by the state respondent. The inquiry officer has not given any opinion on merit of the case. In absence of such opinion, finding of the discovery authority that the inquiry officer has thoroughly been examined at the department level suggests that the discovery authority has not applied mindedness, so and so, not disputed the seven preposition of the law, and thereafter 43B has been quoted by you. From the perusal of the record, it appears cause of action as per the memorandum of charge and the reply given by the petitioner in terms of the so-called notice appears to be erosion between 17/2/2014, 4/9/10/2004. The departmental proceeding was initiated on 28/7/2009 as is evident from annexure 1.
So by 28/7/2009,
9.
the petitioner was asked to respond to the charge.
May. It will take some time, my lord, but I am coming to the question is already been answered in all three judgments. That I want to.
No, you see, this finding is, there was a charge memo prepared on 27/7/2009. It was forwarded by letter dated 28/7/2009, wherein the petitioner was asked to respond to the charge memo. The court says that on 28/7/2009, the proceeding was
Initiated. In my case also, Mayor, that I am coming, that the question with regard to issuance of memorandum, which shows for initiation of proceeding is must. Therefore, I am pleasing.
okay. I have read this judgment. You are referring to this paragraph, para number 16.
Explanation, so paragraph 16, उसी page में. In view of the explanation I cited in above, in the present case, departmental proceeding is said to be having initiated only with effect from 27/7/2000, that is when the memorandum of charge was issued, or on 28/7/9, that is when the resolution was passed for initiation of departmental proceeding.
That's it.
Hence, the memorandum of charge was issued admittedly after 4 years from the date of alleged, whereas resolution pertaining to such memorandum of charge, that is important before your lordship to consider. Memorandum of charge was passed on 28/7/2009. This is my lord. They have taken the case of, and this judgment whereby the punishment order has required, a state had moved in appeal. That is annexure 7. Page start from page 64.
Yes. Yes.
Para 5 of the page 65. The writ petition received memo of charge dated so along with the copy of the resolution In the present case, the memo of charge.
You see, don't mix it like this. When you are placing the judgment, you place the judgment.
Along with the copy of the resolution bearing memo number so and so issued by the present appellant, when a decision to initiate departmental inquiry against the writ petitioner under rule so and so was taken. Writ petitioner was directed to submit the defense before the inquiry officer. It is further not in dispute. The allegation for which the period when the petitioner was posted so and so, my lord. Para 7. Case of the present of the London Reed Court was the after cadre allocation so and so. It was decided to initiate a departmental proceeding under section 43B of pension rule for prima facie proof charge committing irregularity. Accordingly, water resources resolution for initiation of departmental proceeding against the writ petitioner by memo number so and so so and so. Competent authority examine the inquiry report as well as the other document held so and so. Thereafter, your lordship, that is para 12.
Yes, I have read it. This is my judgment. This is authored by me. I know about it.
Only the question, subject to your lordship, only the question involved in this case, the memo of charge which has been framed by Deputy Commissioner on 19/12/17, which was sent to the Urban Department. Urban Department has sent to the Personal Department. Personal Department sent to me that this is a charge. What you have to say against this charge? Accordingly, I replied the charge in July 18 itself. Thereafter, after receiving my reply, it was immediately forwarded to the Urban Department. Immediately, because the DC has framed the charge. Personal Department only being my controlling department, he sent the Urban Development. Urban Development from 18 to 2022, no reply. And the Urban Department has filed the counter stating therein specifically that after receiving the letter from the Personal Department, my reply was forwarded to Deputy Commissioner Chatra.
Where is the communication from the Personal Department to the Urban Department? Where is that letter? Where is that letter? Where is that letter? From Personal Department to Urban Department.
Yes. It counters specific therefore.
Where is it? Please place it.
Lordship, that after receiving annexation page
40.
Page 40 of the counter filed in August 2023.
That's right.
The Lordship got it. Satish Kumar Jaswan Sachiv Nagar Vikas Ravinder Kumar को सदर आरोप स्पष्टीकरण पर भवादीय मतलब सिर्फ उपलब्ध कराने की कृपा की जाए. लास्ट लाइन. After again next page. In 19 अनुरोध किया गया था जो अब तक अप्राप्त. अतः अनुरोध है कि वांछित वक्तव्य शीघ्र उपलब्ध कराई जाए. Thereafter next page 27/12/19 अनुरोध किया गया था जो अब तक अप्राप्त. फिर 20 जुलाई को भी लेटर इशूड बाय द सेक्रेटरी.
सुन लिया आप लोग को.
वांछित है. And thereafter, your lordship, very important thing, one counter has been filed in January 2024 by the Urban Department. Only one paragraph I will read. They have enclosed all the documents. Para 11. फाइल 4-5 जनवरी को फाइल हुआ होगा, 3 को एक फाइल हुआ है, 4 को लास्ट काउंटर है।
क्या बोलना चाहते हैं सर? प्लीज फास्ट।
उसमें ये बोलना चाहते हैं ना, हम कुछ अर्बन डिपार्टमेंट ने भी बोला कि जब only one paragraph I will read.
You just tell us what is the content of the paragraph.
कंटेंशन जो पर्सनल डिपार्टमेंट ने उनको 18 में भेजा था, आपको 23/8/18, 25/7 को हमने जवाब दिया। देर आफ्टर ये आस्क्ड ओपिनियन। उसके बाद अर्बन डिपार्टमेंट ने डीसी को लिखा सेवरल लेटर्स अप टू 2022, नो रिप्लाई, मीनिंग देयर बाय बोले हम बस सॉल्यूशन करें। The reply which I filed in pursuant to the above charge framed by the Deputy Commissioner, they have not responded. Either they have accepted, not accepted. For 18 to till date, till January 2023.
That is all.
And therefore, taking into account all the contention, 19/12/23 order has been passed by the coordinate bench with a query with regard to the specific.
Now you are repeating your submissions. Please don't repeat.
And thereafter, one NHR 88 I took place. The contention raised NHR 8, page 72. Page 72, paragraph 4. Page 70, paragraph 4. On the other hand,
This is a submission.
क्या उसका रिप्लाई है? सबमिशन के बाद ऑनरेबल कोर्ट का क्या है वो पेज में। On the other hand, Mr. So and so, JC to so and so, as per the explanation attached, what my learned friend is saying, provision of the aforesaid rule, it is clear the departmental proceeding will be deemed to be instituted from the date on which the charge served upon the delinquent retired implied. She further submit that from the preamble of NHRA counter affidavit, it is clear charge was framed and served to the petitioner on 11/9/12. Under the said circumstance, Rule 43 we so no application in this case. Accordingly, Learned Counsel submit that there is no illegality and initiative. Thereafter, your lordship kindly turn to page 74. Para 8. In the instance case, it is not disputed that the departmental proceeding initiated against the petitioner relates to event would take place in between so and so. However, Learned Counsel for the respondent state submit that charge has already been served upon the petitioner on 11/9/12, and therefore it will be presumed that the proceeding has already been initiated in 2012. That is within 4 years from the date of event. Aforesaid submission of the Learned Counsel for the state appears to be misconceived. I have already noticed that the present proceeding initiated in 43B of the Jharkhand pension rule. It is an admitted position that the petitioner retired on 28/12/2013. Thus, if according to the state government, departmental proceeding has already been initiated in the 2012, then the same ought to be initiated under the civil service rule, not under Jharkhand pension rule. And taking into account all those things, the court had made the specific query by the Learned Counsel that whether the memorandum of initiation or proceeding was initiated in the year 2017-18 or 23. They replied to that.
That's right, we have seen.
That one paragraph of.
We have heard it, we have seen it, we have heard you enough, right? But the point is that the list of dates that you have given.
That I will give. By tomorrow.
By tomorrow. You also
tomorrow.
give the revised list of dates. You have also not given the basic dates.
I have given notice.
No.
Yes, sir.
After 2012.
I
Date of
got the
appointment.
point, my lord. Accordingly,
next page
I will give the
Is there
date.
any date which is missing in this? 25/7, then you have 23/8, 31/12,
I will give all dates.
all that.
I will give by tomorrow.
I've got the
Lordship,
list
one
of
full bench judgment I have quoted, Lordship. It is clear from that the date of departure was deemed to start on the date of serving of the chargement.
That is not only, but you have
In
not
both the
taken
judgments,
decision
Lordship.
for
First case is not
initial
applicable in this
procedure.
case, Lordship. In that case, already the delinquent has superannuated it. Now superannuated.
You give your revised note.
Was served, Lordship.
By tomorrow you say that you will give
Tomorrow or day
arguments of
after, as you
the,
know.
then by tomorrow. The arguments of the parties is concluded. The petitioner undertakes to file a revised list of dates and points for consideration by tomorrow at 10:30. By
Complete
2:15.
governance committee.
Pose
I am
this-
sorry, I will.
Pose this case for dictation in open court on a Thursday to be taken up at 4 o'clock. 4 बजे लिखाएंगे हम कोर्ट में. आप अपना सबमिशन दे दीजिए. ठीक है?
I have given Lordship one more.
Only that is the only point.
You give your revised date because you have not given the basic things that you are arguing. You refer to the paragraph number of the,
Judgment which I have.
not only of the judgment but also of the counter affidavit you are referring to. You please refer to those paragraphs.
Online.
Item 3, WPS 7.2.7 of 2023.
Petitioner. ये जो जजमेंट सोमवार के लिए CCL वाला. Yes, petitioner. What is your relief?
Leadership, at the very outset, I would like to say that on the last occasion there was a direction to file counter affidavit. That has not been filed, but this morning I have taken instructions that concerned respondents are praying for 10 days for that time.
What is the relief?
This is regarding that the petitioner was selected and his name appeared in Annexure 3, that is the list of successful candidates for the post of assistant teacher at District Koderma. And they have already, he has submitted his joining, but they are not issuing him the appointment letter.
So you file your representation, you
Yes,
will
yes.
get your appointment letter pursuant to 2019. We do not know.
19, yes,
You are, everything counselling was done, you were successful?
Yes, yes. Annexure
Consider
3 is
his-
already there.
WPS number 7.2.2.7 of 2023. The learned counsel for the parties are present. Counsel for the petitioner has submitted that the petitioner had participated in the selection process pursuant to the advertisement issued on what is the number of advertisement?
Advertisement number was 4 of 2015. This is the same matter relating to that counseling.
You have not even mentioned it in your petition.
Yes, Your Lordship, that is because the advertisement was district-wise advertisement was there.
We do not know. Such sketchy petition, you don't even mention the advertisement number.
Your Lordship, in several affidavits
Pursuant
it
to
has
the-
been coming advertisement of the year 2015 it will record.
Pursuant to the advertisement
Of the year
Number-
2015. Advertisement number 4 of.
number 4 of 2015, though the advertisement number has not been mentioned in the writ petition, but learned counsel submits that the petitioner had participated pursuant to the said advertisement. He submits that the petitioner obtained 58.66 marks after counseling and was declared successful, and his name appeared in the list of selected candidates for the district of Kodarma, but no appointment letter has been issued to the petitioner. The learned counsel has submitted that he has raised his grievance before the
Then it was before DSC, District Superintendent.
You have not raised any grievance?
Your Lordship, since my certificates, everything is already, original certificates are still with the respondents. They are not issuing any.
You have not raised your grievance before anybody?
I have made the statement that I have.
Where have you made the
Yes.
statement?
And the oral submission they have denied.
Where is it?
Para 13,
Para
13, page number 10, Your Lordship, of the
30.
reputation.
The learned counsel has submitted that thereafter that it has been stated in para 12, 13 and 14 that the respondents are sitting tight over the matter and they have neither issued appointment letter to the petitioner nor provided any information to the petitioner regarding his appointment. And the petitioner has made several visits to the office of respondent number 4. And ultimately the present petition has been filed. Considering the nature of relief as prayed for by the petitioner, and the petitioner claims that the petitioner had participated in the counselling and was declared successful, but no appointment letter has been issued to him, this court is of the considered view that the matter is required to be looked into by the respondent number 4, before whom the petitioner claims to have visited time and again. In spite of order dated 13/2/2024, no counter affidavit has been filed. Today, the respondents are seeking time to file counter affidavit. However, considering the nature of relief and the averments made in the writ petition, this court is of the considered view that no useful purpose will be served by giving further time to file counter affidavit. The grievance can be looked into by respondent number 4. Accordingly, this writ petition is disposed of, enabling the petitioner to approach respondent number 4 by filing a representation giving the details with necessary details and along with a copy of the writ petition. Upon filing of such representation, the respondent number 4 shall pass a reasoned order with regard to the claim of the petitioner, and you need hearing? You need hearing? No hearing is required.
No hearing is required, only they have to accept the.
And the reasoned order we communicated to the petitioner through speed post. Reasoned order का time frame दे दीजिएगा. 15 days from the date of representation and 1 week from today to file the representation. इसको order को upload करें. एक हफ्ता में नहीं फाइल करिएगा तो extension of time के लिए मत आइएगा, हम नहीं करेंगे. Because para teachers matters is absolutely fluid. So I do not.
Now they are going to conduct the same counselling by Lordship's order in the Honorable Division Bench.
We do not know whether this post will also be
Yes,
re-advertised.
this will be connected to that.
We do not know.
They will come up with the fresh vacancies in this same advertisement.
From supplementary list for final source item 1, WPS 4714 of 2023.
In this case, my lord, the madrasa is question. The madrasa in question is fully aided by the state, my lord, and it is run on the basis of the aid provided by the state government. Therefore, as per settled law, my lord, if any institution, corporation, or society is
As per
aided-
Jharkhand Education Tribunal
Yes, I will
Act.
come to that also, my lord. I am submitting that it is an state under Article 12. Thereafter, my lord, the JET Act. My lord, JET Act, Section 8 says, my lord,
No, you come to the background of it, the very
my
preamble
merit
of
of the
it.
case, my lord.
The very preamble of it. It is
Ma'am.
meant for aided, affiliated, and private educational institution. All three. Aided, affiliated, and private medical institution.
It is there,
Private
my lord. It
education.
is there, but my lord may see the Section 8. It says, my lord, Section 8 says, matter concerning recruitment to any post in connection with the affairs of the educational institution. Everywhere educational institution has been stated, my lord, and my lord may see the definition of the educational institutions, my lord, in definition Section 2. Educational institution means any educational institution managed and administered by private management located within the state of Jharkhand. My lord, in this regard, my submission is this, my lord, that the management of madrasa is not a private management, because the members who are there in the madrasa, my lord, are, my lord, head Maulvi. First 8 members are there in the management of the madrasa: head Maulvi, assistant teacher, educationist, donor member, DO, district education officer, SDO, sub-divisional officer, MLA, local MLA, and representative of the JAC. Therefore, this management committee, which is approved by the JAC, is, as per my submission, my lord, it is not a private management. Therefore, as per my submission, the case is maintainable before this court, because
And not
JAC
before JAC.
not before JET.
Where is it mentioned that what is the constitution of your committee? Where have you mentioned it?
My lord, my lord,
Where is the constitution of madrasa appearing from this particular
my
record?
lord, my madrasa is very old madrasa. It has issued a rejection order in.
I
on
want
behalf
to
of-
know, you said that it consists of 7 or 5 members. From where do I see it from
My
this
lord,
record?
in this writ, my lord, I have come for the promotion of the petitioner. These
for
things,
last several dates,
my lord,
right?
my lord,
We want to examine whether this Jharkhand Education Tribunal
No.
will apply to this institution or not.
No.
You say that it is not privately managed,
my lord.
right?
Therefore-
From where do I see that it is not privately managed? From where do I see this?
My lord, because my lord, my appointment has been approved
No.
by the JAC. JAC is
No,
JAC is
approval
giving
is another
approval.
thing. For all the aided minority institutions,
Ma'am.
the approval is done by the state government,
Yes.
right? They are not managing it. They are supervising it. There is a difference between the two.
Then in the management committee, state authorities
But you
are
have
also
not
there.
stated it. It is not there. You have to. We are not going to
My
entertain
case
the
is not on
repetition.
the point. My actual writ is.
Your case is rightly on the point. At this stage, is on the point whether the writ petition should be entertained, in spite of there is a specific provision of Jharkhand Education Tribunal. You say that it is not a privately managed body.
No.
You should be conscious of this fact that this judgment is going to affect everybody, all madrasa, right? So you can argue anything beyond the record so lightly, but we cannot give a decision so lightly.
My lord, in this regard, JAC may also assist.
No,
my
no,
lords.
no. You have to make out your own case. You say that your constitution, everything, you bring it on record.
These are admitted. There is no any
No,
dispute.
what admitted? Now counter affidavit has not yet been filed. You say admitted. We do not know. You bring on record that this is the constitution of madrasa, and therefore Jharkhand Educational Tribunal will have no role to play, and it is certainly a government school for all purposes. Then they will monitor. They will do everything.
Not government. It is
Then what? Then what?
state under Article 12.
Merely because an institution is receiving aid, it becomes state under Article 12.
My lord, it is the constitution bench of the Supreme Court of 1991 in the Ajay Hasia case. 8-factor test was given in the paragraph 9,
just,
my lord.
you are not understanding what I am
I am
saying, nor you
understanding.
are understanding the
My lords,
contours of the.
My lords want
Of
to
your
go
argument.
to the root of my institution.
You just cite judgment. Things which are not on record, I will not take into consideration. Anything which is on record, I will consider. Your oral submission as to how the madrasa is constituted and how this madrasa, who all are the members in the board, I will not consider it if you don't bring it on record. We will not consider it like this. It's a very serious matter. Then we have to declare accordingly that it is not a privately managed institution, it is run by the government, so we have to declare it.
Yes, since I am raising this question, my lord,
So
let
you-
my lord, state and Jack
No,
also
no. First you satisfy, first you say that it is managed, you just say that it is not privately managed. You bring it on
Then
record.
some more time may be given. I will bring on record all those documents, my lord, because my lord, certainly it will affect several cases. So many cases.
Sir, but you are absolutely
pending before this
non-serious about such a serious issue.
My lord, I am showing from my submissions
For
also, my
last
lord.
3 dates, the maintainability of this particular writ petition is being argued. Last time you
No, I
said,
have not argued today. Last day I
online you
was
were
online,
there,
my lord.
you said that
This
you will
question was-
satisfy, there are citations which are absolutely in your favor. Show me that citation.
My lord,
That so far as madrasa is concerned, Jharkhand Educational Tribunal is not applicable. Show me that citation. I will pass the same order. There is no problem about it.
I am satisfying from other judgments, my lord, that which says, my lord, I am state under Article 12 and management committee, then I will bring the approval order
Your
of management
minority
committee.
status will be at stake. Do you understand the consequence of your submissions? We can't decide and such an important issue like this.
Preamble is there,
It's
my
very
lord.
clear.
Aided is
Aided,
also there in
affiliated,
the preamble, but it is
private
not
education
explained in
is-
anywhere in the Act of JET. JET Act is, there is no explanation.
Need not be.
It
This
says only
act
the-
is very, very clear. Aided, affiliated and private educational institutions are covered by this act. Even if it is an aided institution, it can be privately managed.
But section 8 says management of the educational institution, and educational institution is my lord, defined as a privately
In
managed.
all the aided institution also, they have this kind of arrangement. What do you say?
In also with
Madrasa is not covered by JET.
It's covered also in one of the cases which the college is still fighting before this honorable court for stating that he has attained the minority status, and the minority status was given by the minority commission. But we are fighting on that point that the state of Jharkhand has not approved
Conferred
that.
the minority
So in that case also the honorable court has sent all the parties to JET.
Even
Since it has
section
been
8 is
Maulana
also
Azad
not,
College,
It's very,
even
very
section 8 is also covered the case of the petitioner.
Same college?
No, not same college, university. I think that my learned friend is arguing on definition of state. So in this case, the petitioner is itself fighting before this honorable court for getting the minority status. Then also the honorable court has sent the employees of the college to JET against the termination order that moved before the JET.
देखिए WPS number 4714 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that in view of the definition of educational institution as contained in section 2 within bracket N, read with section 8 of Jharkhand Education Tribunal Act 2005, the respondent educational institution, which is a madrasa, is not covered under the Act of 2005. The Learned Council has submitted that in the board which administers the madrasa, there are representatives also from the Jharkhand Academic Council and the madrasa is and aid receives aid from the state government. Is that correct?
Even the state authorities are also the member of the
That's
management.
right. Jack, you have said. The Learned Council appearing on behalf of Jharkhand Academic Council has submitted that the Jharkhand Education Tribunal has the necessary jurisdiction to deal with the dispute and has referred to an order dated 27.08.2023 passed in WPS number 1080 of 2016, wherein the termination order was under challenge. The court has referred the matter, has refused to entertain the court has disposed of the writ petition with a direction to the petitioners to approach Jharkhand Education Tribunal for redressal of their grievances. She submits that in that case also, the madrasa was there.
No, it's a minority college.
It was a minority college. After hearing the Learned Council for the parties and after going through the provisions of Jharkhand Education Tribunal Act 2005, the background of the case, the background of the act has itself been mentioned therein in the notification, which reads as under: an act to make suitable provision for constitution of statutory forum to be known as appellate tribunal for looking into the grievance of teachers of aided, affiliated and private educational institution and that of the parents/guardian of the students studying therein, and to comply with the order of Honorable Supreme Court in the matter of TMA Pai versus State of versus Karnataka State and the ruling dated 5th August 2003 passed by the division bench of Honorable Jharkhand High Court in the matter of WPPIL number 2744 of 2003. The educational institution has been defined as under. The aided school has also been defined as under. The Section 8 of the Act reads as under. This court is of the considered view that merely because this court finds from the writ petition that no averments have been made regarding induction of any authority from the state in the management of the madrasa. However, this court is of the considered view merely because one or the other state government authority forms a part of the managing committee, the same by itself will not take away the status of madrasa to be a privately managed school. further the fact that the madrasa is receiving aid from the government by itself will not take the madrasa out of the jurisdiction of Jharkhand Education Tribunal Act 2005. In such circumstances, this court is of the considered view that the petitioner has a remedy before the Jharkhand Education Tribunal in connection with the redressal of his grievances, and on account of the availability of efficacious alternative remedy, this court is not inclined to entertain this writ petition under Article 226 of the Constitution of India. Accordingly, this writ petition is dismissed as such. The petitioner may avail his remedy before Jharkhand Education Tribunal within a period of 15 days from now.
My lord, after tribunal, one can come before this court.
Certainly,
in the division
ACSB.
bench.
वो तो appeal है,
ACSB, it's an appealable order.
Section 15 में,
Section 15
Yes,
is appeal before
it is also important to note that against the order passed by Jharkhand Education Tribunal, there is a statutory remedy of appeal
Yes.
before this court,
Under
which
section
is
15.
under the nomenclature ACSB.
ACSB.
Right? Next.
Item 2, WPS 33.70 of 2023.
Harish, I'm here because of the post-retirement benefits as ordered by the LPA court. They are altered unilaterally by the respondents without giving me any opportunity of
What
hearing.
opportunity?
Plus, altering with my post-retirement benefits, they have recovered a lot of sum without giving an opportunity.
Under what head? Is it a dispute?
Plus, the head, plus because I have annexed the entire show cause which was filed before the content
No.
proceedings.
We are not concerned with the show cause filed in content. You say that they have made certain recovery without granting you
Yes,
an
ma'am.
opportunity. So, what opportunity was required for recovery of rent? You just tell us the quantum as per your calculation. You retired in 2009,
Yes, ma'am.
attained the age of superannuation,
Attained
your
the
dismissal order was set aside in 2017.
17.
As it is post 2019, you were not entitled to retain the quantum, irrespective of your dismissal order.
Yes, ma'am. That is there.
Irrespective of your dismissal order.
Yes, ma'am.
So after 2009, you are bound to pay the rent as per the norms.
Yes, ma'am. That rent part is there, but it is just not the rent part under which the recovery is made. There's electricity dues and
Electricity dues also you are supposed to pay. You must have consumed it.
No, but then again, if this annexure C which was annexed to the show cause issue, but this is a single sheet of paper. The calculation which was made.
You just let me know
Yes, ma'am.
where is your problem. The rent is quantified, right? Electricity dues are something which you have consumed,
Yes.
and there is some loan also.
Yes, your issue
Cooperative
para
loan
19
So that also is recoverable.
and miscellaneous is 85 rupees.
What is it? They will give you the breakup if you want. Then if you have any grievance regarding the breakup,
Yes, ma'am.
then that can
Yes,
be
ma'am. That was also my case because my
show cause, no show cause.
Because my
Only the breakup they will give you regarding the recoveries, and if you have any grievance regarding the breakup, you can raise your grievance.
Right, because after my LPA order, whereby my dismissal was set aside, and I was given the order that I shall be considered into that the restatement of service by the time I had superannuated, so all the consequential benefits was all that is what the LPA court has observed. So now I am under impression that my superannuation 2009. So my benefits and consequential benefits shall be treated me giving continuity in services. That is my impression. Now what has happened?
Continuity in services post 2009.
No, till 2009. 2004 I was dismissed till 2004 to 9 because that under simple head 2004 to 2009.
So as it is post 2009 or any arrear prior to 2009, you are supposed to pay. They will give you the breakup. You give him the breakup. Who will give him the breakup?
I will bring it on record.
No. You don't need to file a counter affidavit. I'll remit it to the authority. Who will give him the breakup?
This was passed by.
Which authority will give him the breakup of his dues which has been adjusted from its post-retiral benefits.
There should the deputy general manager, the
Respond number 4.
4.
Okay, he will give you, if you have any objection to the calculation, you can raise your objection. Simple. Right. If any balance is there,
And preferably if given opportunity of hearing, then if
they will give you everything.
Yes, that is there.
Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner was dismissed from service sometimes in the year 2004, which was under challenge in various litigation.
2005, I'm so sorry, it's
2005, which was subject matter of litigation and was ultimately decided by this court in 2007 in favor of the petitioner. 2017 in favor of the petitioner.
17 was the writ was dismissed. 2019 the LP was.
Okay, the writ petition was initially dismissed on 21/9/2017, and the latest patent appeal filed against the same has been
12/3/2019.
Decided by order dated 12/3/2019, wherein it has been observed that whereby the order passed by the learned writ court WPS number 7204 of 2006 dated 21/9/2017 has been set aside, and the punishment of dismissal from service by the order dated 16/8/2005 and the appellate order dated 9/8/2006 were quashed. It was also observed that the appellant has superannuated from service with effect from 31/3/2009. He cannot be reinstated in service. However, he shall be paid all his post-retiral benefits in accordance with law. The learned counsel submits that thereafter the post-retiral benefits have been paid to the petitioner, but there has been substantial deductions on account of certain loan and rent. He has also submitted that some electricity charges has also been recovered without giving any opportunity of hearing to the petitioner. The learned counsel for the respondents has submitted that the deductions are in accordance with law. The petitioner, even if the petition was pending before this court, the petitioner could have retained the quarter only till 2009 and not thereafter, and therefore the recovery of loan etc. are quantified amount, and there is no illegality in the impugned action of the respondents. However, she submits that if the petitioner approaches respond number 4, the breakup of all the deductions can be given to him. He can also be given a hearing, and ultimately, if anything is found payable to the petitioner, that the same will be paid. If found payable, after hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the petitioner ultimately became entitled to the post-retiral benefits by virtue of order dated, by virtue of judgment dated 12/3/2019 passed by this court in LPA number 546 of 2017, wherein his order of dismissal dated 16/8/2005 and the appellate order dated 9/6/2006 have been quashed and set aside. Admittedly, in the meantime, the petitioner has attained the age of superannuation on 31/3/2009. The facts also indicate that the petitioner has been paid the post-retiral benefits in terms of the order passed by LPA number 546 of 2017, but certain deductions have been made, which is the grievance of the petitioner. In the facts of this case, considering the nature of grievance, it is certainly important for the petitioner is certainly entitled for the breakup of the deductions which have been made, and if the petitioner has any grievance in connection with the deductions, the same has to be taken care of by respondent number 4. Accordingly, this petition is disposed of. With regard to the calculations, accordingly, this petition is disposed of by enabling the petitioner to approach the respondent number 4 along with this writ record and a copy of this order within a period of 15 days from today, upon filing of such representation, the respondent number 4 shall give the calculation detail in connection with the deductions which have been made from the post-retiral benefits of the petitioner within a period of 15 days from the date of the representation, to which the petitioner may raise his objection, if any, and thereafter the respondent number 4 shall pass a speaking order, if any in writing. This shall pass a speaking order after granting an opportunity of hearing to the petitioner. If ultimately any amount is found payable to the petitioner, the same is also required to be paid. The speaking order be passed within a period of 4 months from the date of providing, from the date of objection in connection with the calculation which may be raised by the petitioner upon receipt of the calculation details and be communicated to the petitioner through speed post.
Well, can I request only one thing? Well, instead of having 15 days, can it be 25 or a month's time? Because this is 79 years old man, he comes from a
4 weeks.
8 months.
You give his the schedule of payment, everything. Yes. The electricity charge, 3 charges are there. One is the loan, other is electricity charges, and third is rent.
Right.
Much obliged.
Item 3, WPS 3734 of 2023.
Your Lordship, in this case, the pleadings are not complete. Your Lordship, I am praying 2 weeks time to file the rejoinder and the reply of IA number 89/2024 filed by the respondent, so extension of no interim order.
Madam, 4/12/2023.
The departmental proceeding is, what is the ground to challenge the departmental proceeding? Yes, what is your ground to challenge the
In this
departmental
case,
proceeding without jurisdiction? That could be the only ground. Without jurisdiction.
My senior has to argue this case.
Who is your senior?
Madam,
Call him. They have filed the counter affidavit, they have produced the
Your
rules,
Lordship, they have
regulations,
not filed the
everything.
rejoinder. They have taken 3 indulgence to file counter affidavit. They have delayed the whole proceeding. Now we are only
But we will not extend the interim order, that IA has to be allowed. How much time do you need to file rejoinder? 1 year?
2 weeks, Your Lordship.
2 weeks.
And also to the reply of the IA.
We will not extend the interim order. There is an IA application for not extending the interim order. We will not extend the interim order. There is already an order that you are to participate. No final order will be passed. So you participate, isn't it? That is the nature of interim order.
Your Lordship, in this case, the answering respondents are going to pass the final order. That's why.
No, we will not extend the interim order. You have participated, they are going to pass the final order. Very good.
Let it be 2 weeks to file the
No. We are not going to give it 2 weeks time for this. We will not extend the interim order. We will not. When you want, when will your senior argue this case?
Let the rejoinder be filed, Your Lordship.
By tomorrow? Day after tomorrow?
Next week, Your Lordship.
We file it by Friday? Next week, by Monday? Okay, we'll post it on Tuesday. Learned counsel for the parties are present. A counter affidavit has been filed in the present case.
On 4th January 2024.
On 4th January 2024, no rejoinder has been filed. Counsel for the petitioner strenuously prays for time to file a rejoinder to the counter affidavit. Let the rejoinder be filed latest by Monday.
And it will be 2 weeks.
No. I have already rejected it. I was about to decide the case. You have challenged the departmental proceeding on ground of jurisdiction.
Yes, ma'am.
That is there on record. What else?
I'll bring certain more documents on.
So therefore, you file it by Monday. Let this matter be posted on Tuesday for final disposal. To be taken up at 4 o'clock.
Madam, the petitioner in service, madam, I will have to call him for swearing affidavit, madam. They are not granting leave also, madam. So
They will
therefore, I
grant.
am paying for 2 weeks time so that he can come on Saturday or.
Saturday he will come.
Therefore, madam, let it
He
be
will
10.
come on Saturday. No.
Let it be 10 days.
No,
madam.
no. Then I will not extend the interim order. There is an IA for not extending the interim order. You should have been careful about it. This is a peculiar IA which has been filed, wherein they are claiming not to extend the interim order. Interim order as it is has vacated because it was only till the next date of hearing. Isn't it?
Yes. Let it be 10 days. madam.
No.
Item 4, WPS 3790 of 2023.
Let us see petitioner wise.
Yes, yes. It is for regularization.
So
And
petitioner
it is-
number 1 and 2. They had filed a writ petition earlier.
Yes, Milos.
What happened? You have withdrawn the writ petition.
Yes, Milos. To pursue the matter before the authorities.
Okay. Then what happened? What is the fresh cause of action?
Milos, the authorities have considered the cases of Milos others, but our case was not considered because
When they have considered the case of others.
case 39 of rejoinder if Milos.
So that is not coming up from the writ record.
Milos, similar matter has been decided.
No. You see, you can't have it like this. You file a writ petition. You withdraw a writ petition. And then for the same cause of action, you file another writ petition. Not permissible in law.
We withdraw it to pursue before the authorities.
So therefore, I want to know from the writ petition as to what happened thereafter.
Our
Which
claim
mean-
has not been rejected yet.
So what?
But our
There
case,
is no whisper after the withdrawal of the order. After the withdrawal order dated 33/11/2020, what is the subsequent event so far as petition number 1 and 2 is concerned from the writ petition? To maintain the writ petition.
that difficulty
3/11.
is there. That difficulty is there.
That difficulty is there. I will dismiss the writ petition corresponding to petition number 1 and 2 on this ground.
But at the same time, if my lord will allow me to.
And so far as petitioner number 3 is concerned, he is a driver. He has a different status altogether. So
Yes.
you will confine it to petition number 3. I will dismiss so far as petition number 1
That
and
is
2
there,
is concerned.
but I want to submit also one thing more, that a batch of writ petitions were taken up by this honorable court. हाँ, ठीक है. WPS number 1787 of 2010. Just my lords will have a look to this, not subject to what your ladyship.
2000?
टू 255 नंबर जो मिडिल में लिखा हुआ है WPS नंबर 255 of 2015 relating to the same prayer, same department and similarly situated persons. And this writ petition was disposed of, nurse. No nurse relief was granted, but nurse, the respondents were directed to consider and take a decision.
You were also there in that case?
No, the petitioners were not. That is why they are not being considered. कि उस केस में आप नहीं थे.
ऐसा नहीं होगा ना. ऐसा नहीं.
So this is the only ground
No.
which I am taking, that since we were
You
not
have to make out a fresh cause of action
not there in the
for filing a fresh writ petition.
so the persons are continuing on the same post in the same manner till date.
We are not concerned.
That is the first cause of action.
No.
That others' case has been considered in the light of this judgment. Our case
You
is not
see,
being
you have to
considered.
disclose your cause of action in the writ petition.
That is not there.
That is not there, so we will not
That-
entertain
that
the
I am
writ
saying.
petition. This
But
is the practice which has been adopted in the High Court. You withdraw a case and file the fresh case on the same cause of action. This I will not permit. I've noticed it. This is not the solitary case. I've noticed it. Number of cases. This we cannot. You cannot say ना आज बड़े बढ़िया कोर्ट नहीं है बढ़िया इसको withdraw कर लेते हैं फाइल फ्रेश.
ये कहाँ हम लोग कहते हैं?
ऐसा ही होता है. हमको पता है.
आपके टाइम में होता है.
कहानी मत सुने ये. हमको पता है.
उस टाइम में होता था. आप नहीं बोलते ये बात. And my lords, what I am saying, ये जो केस है इसमें कोई जजमेंट नहीं है कि हम इसके बेसिस पर हमको कुछ मिल जाएगा बहुत.
कुछ नहीं.
इसमें क्या जजमेंट है कि you consider and take a decision. They considered and took a decision, and all those 29 numbers, my lord will just appreciate this subject to I leave it upon my lord. All those 29 in numbers almost, except 2 minutes, persons were considered and all have been regularized.
We do not know things which are not on record. हमको तो सुनाई भी नहीं देता.
नहीं तो हम तो रिकॉर्ड से दिखा रहे हैं ना. पेज नंबर 39 देखा है.
नहीं आपका ये
Because I know
पिटिशन
that
नंबर
you-
1 and 2 के बारे में हम कुछ भी ऑर्डर नहीं करेंगे.
My lords, I know that
पिटिशन नंबर 3 के बारे में क्या बोलना है?
your ladyship will go only by the records. Page 39 for a minute kindly see.
39 और
Rejoinder.
yes,
Madam, the case number is there, in third line from the top. WPS 255 of 2015. The judgment the order which I am referring to, 255 2015. Since the matter was relegated to the authorities have taken a decision and all these persons have been regularized. My only this much prayer is that they may be allowed to consider my case. I am not saying that my lords may straightway grant me any relief.
So therefore, by virtue of the last order, you still have a remedy to approach them. I will not pass any order. You have not approached them by virtue of last order. You have simplicity withdrawn the petition.
No, these are the only thing my lords.
So far as petitioner number 3 is concerned, he is also of the he is of a different. He is totally different. He is a driver. ड्राइवर को घुसा लिए इसके साथ.
केस कंसीडर उसका नहीं.
तो वो अपना जो भी स्कीम होगा उसके अनुसार कंसीडर करेंगे. We can't do anything.
Well, these are the facts, my lords.
Yes. This petition has been filed for the following relief. The learned counsel for the petitioners has submitted that the respondents have considered the case of survey inspectors.
हिंदी में परिमाप निरीक्षक बोलते हैं, सर्वे इंस्पेक्टर.
Survey inspectors recently on 7/8/2023 and passed an order of regularization of some of them. The learned counsel submits that the case of the petitioner number 1 and 2 stand on similar footing, but his case has not been considered. He submits that the order has been passed pursuant to order dated 27/7/2023, passed in order dated date बताइए.
ऑर्डर का डेट है 7/2/2019.
7/2/2019.
Passed in WPS number 255 of 2016.
Passed in WPS number
255 of 2016.
255 of 2015, which was a part of batch of cases being WPS number 1787 of 2010 and other analogous cases. So far as petition number 3 is concerned, this case is on a different footing, who claims to have been appointed as a driver in the settlement office in 1998 against a vacant sanction post. With regard to petitioner number 3, the learned counsel submits that his case for regularization may be considered as per applicable scheme of regularization. That's
Yes.
it. After hearing the learned counsel for the parties, it appears that the petition number 1 and 2 had approached this court in WPS number 3037 of 2019, and the writ petition was dismissed as withdrawn by the order dated 3/11/2020 on a submission made by the learned counsel for the petitioners to seek permission to withdraw the writ petition to avail the alternative remedy. From the perusal of the writ petition, it appears that there is no averment with regard to any step taken by the petition number 1 and 2 after order dated 3/11/2020, and now they have filed the fresh writ petition. In such circumstances, this court is not inclined to entertain the writ petition with regard to petitioner number 1 and 2. However, the same will not be an impediment in way of the petitioner number 1 and 2 to approach the competent authority by way of alternative remedy for the redressal of their grievances, inasmuch as in the rejoinder it has been brought on record that certain decision has been taken with regard to some persons which the petitioners claim to be similarly situated as that of petitioner number 1 and 2. हो जाएगा काम?
टाइम दे दीजिए कितना दिन
नहीं, उतना नहीं, हो जाएगा.
उतना सा से हो जाएगा.
इतना ही बहुत.
उतना एक लाइन खाली
So
लिखा
far
है.
as petitioner number 3 is concerned,
It's High Court direction one.
हम लोग को अपने ना judicial discipline से बहुत ज़्यादा मतलब है. So far as the petitioner number 3 is concerned, he may also approach, from the records of this case, it appears that he has come before this court for the first time, and in such circumstances, if there is any applicable scheme for regularization, his case may also be considered. It appears that the petitioner number 3 has not attained the age of superannuation, 46 years. For the said purpose, the petitioner may approach the respondent number 3, director. Respondent number 3, within a period of 1 month, 1 month from today, along with the writ records and a copy of this order. Upon filing of such representation, the respondent number 3 shall seek the necessary information from the other respondents, particularly respondent number 5.
Yes.
Particularly respondent number 5 and 6, and pass appropriate order in connection with this claim for regularization as per applicable guidelines/circular. It is observed that the question of while considering the question of regularization, the matters of similarly situated persons is also required to be taken into consideration. The needful be done by respondent number 3 within a period of 6 months from the date of representation.
I'm sorry.
From daily list for financial item 1, WPS 2543 of 2023.
Petitioner, he submitted his candidature
for the post of assistant engineer in pursuance of an advertisement issued by the Jharkhand Public Service Commission. The online application was submitted, and thereafter he appeared in the preliminary examination. And when he qualified in the preliminary
Where is
examination,
your written submission?
that has been submitted along with the judgments.
Not
It has also been given on.
You have also filed? What is the crux of the issue?
The crux is that there was a format for submitting caste certificate along with the advertisement. Format 11. The petitioner has submitted the caste certificate issued by a competent authority, but not in that format.
Same authority.
That doesn't mention any authority that has been issued by the subdivisional officer. The certificate which has been submitted by the petitioner.
Where are the two caste certificates?
Yes.
Where is the format and where is the caste certificate?
Yes. That format is at page number.
There is an order of rejection?
Yes, at the last stage.
Maybe at any stage you can.
The advertisement, I will just explain. The advertisement provides that after the online examination, there will be a verification of the documents. I produced my documents. It were required to be
Where
sent.
is your caste certificate?
My caste certificate. Yes. Those are page 48 and annexure to page 48. The caste certificate which was (48) and 49.
This is form number is not mentioned. This is issued by the circle officer.
The first one is issued by circle officer, and the second one, page 49, that is by the subdivisional officer.
This is after. And
Yes.
what was the requirement? It
The
should be
requirement
produced by
was-
whom?
The reason is that it should contain the non-creamier certificate, and that declaration is there in this page 48 also.
No, what was the format of
that is at page 108.
108? It is not identical. The contents are not
The
identical.
sum and substance.
No, maybe sum and
Now, the
substance.
first thing, the things which the petitioner want to contain. Now, I will just explain it. The advertisement provided that once the person who qualifies in the preliminary test, they have to send their certificates, all certificates including caste certificate by speed post. The petitioner qualified, he sent the caste certificates by speed post within time. His case was considered and he was allowed to appear in the mains examination. He submitted this caste certificate. Thereafter, the advertisement also provided that those who qualify in the mains examination, their document verification will be done. Now they have to go physically for document. And the advertisement clearly provides a stipulation that persons whose documents are found to be correct or whose documents are verified, they will only be allowed to appear in the interview. Petitioner, after qualifying in the main examination, he went for document verification and he produced the certificates. The first certificate which he submitted after the preliminary examination, he produced that. There they said that since this certificate is more than 1 year old, you show some other certificate. Then he produced another latest certificate. That was there. And thereafter he was allowed to appear in the interview. Meaning thereby his document verification was done, he was allowed to appear in the interview. And thereafter, though he otherwise qualified, he obtained the marks more than the cut-off marks fixed for the backward category candidates, BC1.
BC1 or BC2?
BC1. BC1. So he obtained marks much more than the cut-off marks which was prescribed for BC1 category. But thereafter the commission came out with a stipulation that candidature rejected for submission of caste certificate in central format. That is the crux. They say that it is in the central format. And now only one thing which is important, which may be a justice-oriented approach. Here the caste certificate, the format which they give, page 108, that refers to Office Memorandum 8993 of the Departmental of Personnel and Training, Central Government, Government of India, 8993, which provides for that
non-creamier certificate. Page 108, the last paragraph mentions that. And paragraph 3 is 10/6/2002 and 8/9/93. Following that, all these documents have been brought on record by way of rejoinder. All these documents have been brought on record. These office memorandums as well as the state government. Now the certificate which the petitioner has submitted, if that is seen for a moment, that is also issued with reference to the same said office memorandum of the central government. So the sum and substance, the requirement is same.
Does your certificate reflect non-creamy?
Yes.
Show me that sentence.
Yes. Page 48.
Page 48.
Yes. Paragraph 2. Sher Muhammad, that is the petitioner, and his family resides ordinarily in village such and such, such and such. This is also to certify that she does not belong to the person sections within bracket clearly mentioned in column 3 of this schedule to the Government of India, Department of Personnel and Training, Office Memorandum dated 8/9/93, which is modified by the Office Memorandum dated 9/3/2004, or the latest notification of the Government India and Professor System. So there is a clear certification, and this same Office Memorandum is referred in the prescribed format, which is the prescribed format with the Commission's advertisement.
You see, this community, Momin Muslim caste,
yes,
it is recognized as backward class.
Yes.
Right?
Yes.
There are number of notifications mentioned.
Yes.
Which is the notification of the state government? Which notification is referring to the notification of the state government?
About that?
Yes, tell us which resolution. There are so many resolutions mentioned. Gazette of India, then you have this Gazette of India, then Roman 3 is also Gazette of India.
This Honorable Court is raising a query as to which notification is
of the state government is mentioned in this particular notification.
About the Momin subcaste.
Yes.
About the Momin subcaste. That instruction I do not have.
No, you don't need to. You have to show it from the ex officio. You have to show it.
Because the other certificate, which is the format,
you see, all the notifications
because there is
are referring to the notifications of the central government.
Yes. That is there. That I submit.
Then how this particular certificate can be taken into consideration so far as the respondents are concerned?
Because Momin, it is not disputed that Momin
no, it
does
is
not
not a matter of
BC1.
dispute or not dispute.
Because my caste status is never disputed.
No.
Only the rejection is because that I have submitted in central format. That is the only reason.
You see,
the Momin caste is not a backward category annexure 1 member. That is not disputed. The caste status is never disputed. The only thing is that the rejection is because it is in central format. And all throughout, the petitioner has brought on record all the certificates which have been issued to him or his father, or even his father from since long. All the certificates he has brought on record, including the residential certificate and the caste certificates, showing his subcaste and showing his specific category. Throughout it has been shown. And these office memorandums have also been brought on record by way of the rejoinder. And the advertisement itself says that the advertisement itself...
I heard you. Yes, Abatai.
My lord, kindly see what my lord he has argued, your lordship, that is not the correct proposition of law and that cannot be accepted, your lordship. Because your lordship is well aware that for the state government there are two castes, your lordship, under BC. BC1 and BC2. For BC1, your lordship, different criteria is mentioned for having not within the creamy layer, and BC2 is different criteria, your lordship. And after every 3 years, your lordship, the person concerned, your lordship, the state consider the status, etc., your lordship, of liftment, etc., and thereafter, your lordship,
just revise from time to time.
Time to time. At one time, your lordship, the BC1 can be, your lordship,
within creamy layer, or because the financial status will vary.
BC1 can be BC2 and BC2 can be BC1, your lordship.
No, that will depend upon the notification.
Notification, your lordship, after every 3 years, your lordship. And on that issue, and my lord, the other backward class is concerned, your lordship, that is for the central government services, your lordship. Because your lordship, for the union services under the state government of India, your lordship, there is only one category, that is other backward class, and that is guided by the notification issued by the central government, your lordship. And as such, your lordship, this certificate.
No, the central government issues a separate notification for OBC.
Madam. That is mentioned, your lordship. If your lordship see the page number 48 of the writ application, your lordship, from the top, your lordship, Office of the Circle Officer, Gomia, Bokaro, certificate of applying for appointment to the post of admission to central education of institutions such as under the government of India. उसके बाद देखा जाए, this is to satisfy that such and such belongs to Momin Muslim caste, which is recognized as other backward class. Under resolution number, all the resolutions have been mentioned, your lordship, of the Union of India, not a state. And my lord, this certificate.
And here also category 1, category 2 has not been mentioned.
Not been mentioned, your lordship. And as such, your lordship, the requirement was, your lordship, BC1 and BC2. My lord, kindly have a look to the
different requirements and different cut-off marks also.
Different cut-off
and different
marks.
Reservation also.
Percentage of reservation. That your lordship can see in the advertisement. Can be turned to page 60, annexure 4.
Yes.
At top, your lordship, if your lordship will see on UNR, EWS, ST, SC, and thereafter BC1. Different post, your lordship.
Page 60.
60, your lordship, of the writ application. My lord, it appears, your
Yes,
lordship,
UNR, EWS, ST, BC1, BC2 has a different BC1,
and,
BC2.
Different posts are also there. Then your lordship kindly turn to requirement, your lordship. My lord, what he has argued, your lordship, that is not correct, your lordship. My lord, once he has accepted the terms and conditions.
No, we are not agreeing with him. Where is the order of rejection?
The rejection order.
Show me the rejection order.
Yes. That is the result.
My lord, before that,
annexure 9.
Ek minute.
That is annexure 9 at page 74.
Yes.
Annexure 9 at page 70. Here, this result has been published, and lastly, it has the remarks is there. The very last line: candidate got benefit of BC1 category in PT, and mains result, but caste certificate submitted in central format. Hence, candidature rejected. This is the reasoning. Now, what is being argued? That is neither in the counter affidavit nor in
your
the
certificate. Is it reflecting that you belong to BC1 category?
It mentions moving caste, other backward category.
Other backward category is a separate category. It has got two different categories.
Yes, I have clearly mentioned in my petition also, and I have also mentioned.
You must have applied under BC1 category.
Yes, BC1 category, and I have mentioned.
But your caste certificate is not indicating
that
you are belonging
that is
to
not
BC1.
disputed. This would be a hyper technical approach for rejecting a candidature at the final stage.
That's right.
And this is against the advertisement terms. If this honorable court kindly comes to the advertisement, the relevant portion of the advertisement, which refers to this, the document verification stage, where I appeared and I have produced the documents. The advertisement is at page, starts from page 60, and the relevant portion which the petitioner would be relying upon is page 66. Starting from page 60, and the relevant portion is at page 66. That is clause 12. Clause 12 इसमें है आवेदन पत्र भरने हेतु आवश्यक शर्त एवं निर्देश. ए इज ऑनलाइन आवेदन के साथ किसी तरह का प्रमाण पत्र संलग्न नहीं करना है, किंतु ऑनलाइन आवेदन में प्रमाण पत्र संबंधित कॉलम में सभी वांछित सूचनाएं सही अंकित करना है. प्रारंभिक परीक्षा में सफल उम्मीदवारों के द्वारा कंडिका 12 क्यू में निहित आदेश के अनुसार ऑनलाइन आवेदन की मुद्रित स्वहस्ताक्षरित प्रति के साथ ऑनलाइन आवेदन में की गई प्रविष्टि के अनुरूप सभी वांछित प्रमाण पत्रों की स्पष्ट एवं पठनीय स्वरूप छायाप्रति हार्ड कॉपी मुख्य परीक्षाकृत ऑनलाइन आवेदन की प्रति के
आप
साथ
इतना क्या पढ़ रहे हैं? You just come to the relevant clause.
yes then B come to B the last line अभिलेख सत्यापन के उपरांत अंतिम रूप से वैध एवं स्वीकृत अभ्यर्थी ही साक्षात्कार के लिए पात्र हो. And I was allowed to, after my document verification, I was allowed to appear in the interview. And these facts I have mentioned in my petition. If I'm allowed to refer, which are not denied, I have referred about this document verification. Paragraph 26. That the original document certificate produced by the petitioner before JPSC on 13/10/22 were verified by JPSC authorities, and thereafter the petitioner was allowed to appear in the interview on 14/10/22. And before that, I have explained in page 25, page 22, paragraph 25. I'm just reading that paragraph. Petitioner reported in JPSC office on 13 October 22 for document verification. The petitioner produced the required original certificates, including his caste certificate, certifying that the petitioner belonged to Momin Muslim caste, which is recognized as other backward class, and certifying that the petitioner does not belong to creamy layer. Petitioner produced the original of the caste certificate dated 29/2/2020. However, the JPSC authority verifying the certificate asked to produce the recent certificate as the validity of the earlier submitted certificate dated 29/2/2020 expired. So the petitioner produced the original of certificate number so and so dated 27/1/22 issued from Office of Sub-Division Officer Bermo before JPSC and submitted a copy of the said certificate dated 27/1/22. So all these certificates were produced, and there is no dispute about the caste status of the petitioner, and the petitioner has been throughout the previous caste certificates which have been brought on record. I will just refer from page 44 to show that it is backward class annexure 1. Page 44, one of the certificate issued in 2017 by SDO Bermo. To substantiate that, page 44. This is of 2017. This is to certify that Sri Sher Muhammad, son of it was for appointment to Government of Jharkhand. Sri Sher Muhammad, son of
Page 46.
44. 44.
This one
44. Just allow me to complete. Page 44. Page 44. This is for the purpose of Government of Jharkhand. This was 2017 certificate. This is to certify that Sri Sher Muhammad, son of such and such, resident of such and such. Then the second line, village Sadam Gomia, is a member of Momin Muslim community which is recognized as backward class under backward class within bracket annexure 1 of Jharkhand Reservation of Vacancies and Posts for Scheduled Caste, Scheduled Tribe, other backward class Act 2001. So it is apparent that he belongs to BC1, and it is also apparent that he was allowed to appear in the mains examination after
that. Don't repeat it.
Yes,
I've understood.
And the last stage, they have rejected only for central format, and whatever is argued, that is neither in the counter affidavit nor in the rejection order.
You are in 226. Satisfaction of the court is paramount.
Yeah, that is there. But certain approaches, like the petitioner, he is otherwise qualified. He has passed.
I've heard you.
Yes,
I've heard you are a very meritorious candidate.
And
you have got much higher marks in the last selected
yes,
candidate.
even more than unreserved category.
That's
and in BC1 category also he has got more than that. And it is in the last stage.
You have got marks more than the unreserved category.
Yes. That is also.
No, then your candidature would have been considered under.
Bring on the record.
Where is the question of bringing on the record?
No. That is there.
That cannot be considered.
No.
It is to be considered unreserved.
I will just refer to that statement.
You were fit to be considered under unreserved because your document was not proper. They do not reject the candidature. That is the law.
That is the law.
Show us that you have received more marks than the last selected candidate of the general category.
Page 24, para 29.
24.
It is page 25,
You read it.
Yes.
Petitioner obtained 442 marks.
Out of 600 marks in section 1 and shown to be qualified, the petitioner obtained 646 marks out of full marks of 1000 and shown to be qualified and selected for interview under BC1 category. The petitioner obtained 150 marks out of full marks of 200 in interview. The grand total marks, written marks plus interview of petitioner being 796 out of full marks of 1200. Then the very next page, the last paragraph. Paragraph 30. The final cut-off marks of unreserved category candidate is 788, whereas the petitioner obtained 796. That is more than the final cut-off marks fixed for unreserved category candidate.
What is your response to para 30?
My lord, I will have to take instruction.
No, you must have filed your para-wise response to this.
My lord, I have not filed.
You have not filed counter affidavit.
My lord, I have filed counter, but not in this paragraph 30, your lordship. In view of the fact, your lordship, my lord, in view of the fact that the petitioner got benefit of reservation in PT examination, your lordship, and thereafter, your lordship, he was declared successful, and when his case was being considered at the stage of the final, your lordship, it was found that the caste certificate as submitted by the petitioner is not correct, and as such the benefit which has been taken by the petitioner in PT examination was illegal. Your lordship.
You have said so in your writ petition, in your counter.
No, my lord, I have not said, your lordship.
No
I have not said, your lordship, I do admit, but kindly have a look to annexure 9, page 74. His candidature was rejected, your lordship. Annexure 9, page 74. Remark. He was declared, your lordship. May I read, your lordship? Candidate got benefit of BC1 category in PT and mains result.
It is mentioned in the impugned order.
Annexure 9, page 74. Marksheet. My lord, if he would have qualified in the PT and mains examination under BC1 category, then the matter under the unreserved category, then the matter would have been different, your lordship. Candidate got benefit of BC1 category in PT and mains result, but caste certificate submitted in central format, hence candidature rejected.
That is the only reason.
That is the only reason.
With the rejoinder, we have filed the office memorandums which are referred in the prescribed format as also in the certificate which has been filed by me. And I have given the compilation of the judgments along with the list of dates. I will just seek permission to read from 3 judgments, a few paragraphs, relevant paragraphs.
You have to continue tomorrow, it is already submitted. WPS number 2543 of 2023, heard the learned counsel for the parties. The learned counsel for the petitioner has submitted that the candidature of the petitioner has been rejected solely on the ground that the petitioner had submitted his caste certificate in central format. The caste certificate which was submitted by the petitioner is contained at page number 48. The learned counsel further submits that the petitioner belongs to backward class within bracket annexure 1, that is BC1 category, which is also apparent from the certificate dated 19/8/2017 as contained at page number 44 of the writ record. However, the same was not submitted before the concerned authority. The learned counsel further submits that the petitioner had applied under BC1 category, being a candidate of BC1 category, and passed the preliminary exam, the mains exam, and at the stage of document verification, he produced the original documents, and upon being satisfied with the original documents produced by the petitioner also participated in the interview and has secured higher marks than higher marks than not only the higher marks than the marks obtained by the candidate even in the general category. The learned counsel has submitted that the rejection of candidature of the petitioner. The petitioner was asked to give a fresh caste certificate as the validity of the caste certificate had expired. Consequently, the petitioner submitted fresh caste certificate on 21/1/2023 as contained in page number 49, right?
No, that is 27/1/22. Caste certificate dated 27/1/22.
27/1/22 at page number?
That is
at page number 47.
47. At the time of document verification.
At page number 47, at the time of document verification, he submits that after being satisfied with the candidature of the petitioner was permitted to participate in the interview, and ultimately the candidature of the petitioner has been rejected on the ground that the caste certificate has not been, the caste certificate produced by the petitioner was in central format. During the course of argument and upon a query made by this court, during the course of argument, it transpires from the perusal of page number 48 as well as page number 47 and 48 of the writ petition that the certificate issued under the central format does not reflect or refer to any of the notification issued by the state government with regard to classification of the petitioner under BC1 category or BC2 category, and the certificate do not reflect as to whether the petitioner belongs to BC1 category or to BC2 category. The Learned Counsel to this has also submitted that all the circulars which have been mentioned in the central format have also been referred to in the caste certificate which is issued in the state government format.
Yes.
Right? The Learned Counsel, appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that the contents and the narration of the certificate issued by Government of India and that of the state government is not one and the same. He has submitted that not only the creamy layer is to be considered, but also the status of the petitioner as to whether he falls under BC1 category or BC2 category is required to be considered. As per the advertisement, there are different there are different policy of reservation for BC1 and BC2 category. And there are different qualifying percentage. And there are different
percentage qualifying percentage.
Okay, percentage of reservation.
Percentage
of reservation with regard to BC1 and BC2 category. The Learned Counsel has submitted that the petitioner, though claims that he has obtained more marks than the last selected candidate under the general category also, but at the same time the impugned order reflects that the petitioner has had the advantage of reservation at the preliminary test as well as the mains examination, and therefore the final calculation will have no bearing once he has availed the reservation at the stage of preliminary class. The Learned Counsel submits that the certificate produced by the petitioner did not reflect that he belongs to BC1 category, and therefore the candidature of the petitioner has been rightly rejected. The counsel for the parties submit that they will place the judgments which have been, some of the judgments tomorrow in support of their respective arguments as the court time is over. Post this case tomorrow for further hearing. Kal hum likhayenge please.
May I seek permission in serial 15 to submit the list of dates and for because it may be taken up next week or something.
Not going to be taken up.
kept at 3:30 because
Okay, 3:30. कल हम लोग कोई और नहीं 4 बजे लेंगे. 4 o'clock. At 4 o'clock tomorrow. चल और कोई 4 बजे के लिए नहीं रखे ना हम लोग. नहीं आ सकते. और कोई अर्जेंट मैटर है किसी का? After seeing the records where the counter affidavit etc. has not been filed, yesterday also I have passed certain orders in my chamber regarding, suppose counter is not filed, then I have given some more time to file the counter affidavit. So similar orders will be passed and the dates will be accordingly posted and uploaded.
Serial 15 is otherwise ready, I will only submit the list of these.
Yes, you submit the list of dates, will take up. These are all contested matters, these are bound to take time.